television and people don't know that. My name is Ace, and they didn't know that. Nobody asked. I never told nobody. But my name
minutes so reflect, Chairman.
Yeah, it is. Let me start off with a little introduction because I'm going to be here for a while because the commissioner. But I'm here specifically to talk on some issues about, and cop brought about it, the honorable cop brought on about the double dipping in the city here. But my name is Ace, ooh, and I've been on this case. Some of those people out there didn't want me all in this place. But it's no mystery, just check the black history. I've been working on some cases involved with a lot of conspiracy. And some people don't like me, cop, but I don't care. But I'm here for my 3 kids and my community. Ladies and gentlemen, I'm here as the czar of the outmigration. Y'all may not know about that, but ask Ed Lee if you don't believe me, because it was passed down through our current Lieutenant Governor Newsom, who will be our next Governor Newsom, and he made it law and order and something of institutionalized here in the city about the black populations going down. Because you would say, what's going down in this town? The black population is going down. And when the benefits comes, we might not be nowhere around. You know what? This 50% hiring is just a bunch of shit. You know why? Because we can't afford to pay this high-ass doggone rent. But down here in City Hall, it gets silly, y'all. What you say is here in City Hall, it gets so damn silly, y'all. You call it City Hall, but I call Silly Hall. You know what? I'm going to tell y'all. Just like cop, I be here all in it, y'all. But at City Hall, don't you want to know what goes on down here in City Hall? Don't you want to know? Wait, let me get back. I'm here today basically to make statements. And this is my first time here, so I thought I'd come on down. Excuse my appearance, but that doesn't make a difference. I'm not here to impress. But I am here to impress on the city and county that we as African-American Negroes, however you want to call us, are in a state of emergency. Despite all the corruption, despite all of this things that's going on in the city by the bay, Newsom put it together, institutionalized, and put a mechanism together. The outmigration, I'm here to talk about that today. My name is Ace, and I'm on the case.
Thank you.
Hello, I'm Larry Bush here for Friends of Ethics. I have 2 issues that are not on the agenda that we'd like to bring up. One is the issue of the whistleblower ordinance, which has been the subject of meetings between several city agencies but has not had a return back to the Ethics Commission. I'm going to hand you copies that I've excerpted from a Patrick Monette Shaw essay in the West Side Observer that lists what's changed from what ethics passed to where it is now. We are urging that you all have another hearing to look at the changes because the changes are significant and we think have a dampening effect on what it does. And because it's very different from what the Commission approved a year ago, it needs to be revetted and it also needs to go through an interested persons meeting. The other issue that I think that we want to bring up is the question of a planning commissioner who has accepted a full-time position at Spur as their advocate. They have a position on a matter that's coming up this Thursday on inclusionary housing. She has taken the view that she's not conflicted on this issue because they have not directly lobbied the Planning Commission, which is a pretty crabbed interpretation of what is a conflict of interest. And I'm disappointed to see in the correspondence with the mayor's office that was advice that came from an attorney who's also an attorney here at the Ethics Commission. And here's a copy of the correspondence back and forth in the mayor's office in which they say that their interest is in seeing that she doesn't have to recuse herself on issues that are important to the administration. That would be this coming Thursday's meeting. The fact is that she is now the advocate for Spur on behalf of for San Francisco policies, and we believe that she should resign from the commission. We think that the commission should send a notice to all commissioners about what constitutes the appearance of a conflict of interest, even if it's not a direct financial conflict. In discussions at a meeting that I was at, she said that she is not paid by Spur but by a foundation, but then when pressed, she couldn't remember the name of the foundation that pays for her salary. And in addition to which, she said at that time that she couldn't resign until the mayor allowed her to resign. That's not the basis for how people serve on city commissions. So we're bringing that to the attention of you and to whoever may be watching this. Thank you.
Thank you.
Mr. Chairman,
Commissioner Cox.
I will wait until public comment has ended, but I do want to make a motion on that subject matter.
Very well, Commissioner.
Good evening, Commissioners. Thank you for having us, giving us this time to speak today. I would also like to thank Mr. Larry Bush on everything he just said, and there is a definite conflict of interest on that commission. But anyway, my name is Trevor Martin. I'm a District 11 resident. I'm the treasurer for the San Francisco Berniecrats, and I am a volunteer field organizer for California Clean Money Campaign, going on 5 years now. We have worked closely with other like-minded organizations like Represent Us, Move On, and Money Out, Voters In, to pass meaningful campaign finance reform, such as last year's Prop T, Berkeley's Measure X1, and the state initiative to overturn Citizens United. And I'm here today specifically to show my full support for Commissioner Keene's campaign finance and ethics proposal. Money and its potentially corrupting influence is at the very heart of complaints about politics in America, and whatever the interpretation of money and speech, Citizens United inarguably allowed wealthy individuals, businesses, and other groups to use money to influence candidates and policy decisions. California, and in particular San Francisco, has been a leader in campaign finance reform, and I thank you for that, though the corruptive influence of money in politics is still quite evident. We live in the richest city in the history of the world, and yet we have the largest wealth inequality gap in America. We are in the midst of a full-blown housing crisis, and I can almost guarantee you that some of the policy decisions and contracts that were granted that led to this crisis were made with developers and campaign contributions and campaign promises in mind, rather than merit and what is most beneficial to the people and public common good. And so again, I'm here to urge you to pass Commissioner Keene's campaign finance and ethics proposal in its entirety. Thank you.
Thank you.
Good evening, Commissioners. Mark Solomon again, or today for the first time. I just wanted to go ahead and associate myself with Mr. Bush's comments about Ms. Johnson, that we have a major public policy decision that will have bearing on the complexion of our East Side communities for decades to come. And what we have in our unique citizen form of government is a place where San Franciscans are basically completely excluded. We see a commission form of government that in this case is a developer form of government. And we're looking at a major decision here where San Franciscans are basically not at the table, even from the representation side. We have these hapless affordable housing people who are dumping this question into the Planning Commission without having thought about it. So they're basically setting us up for an ongoing shift of affordable housing away from what they want because they can't execute again and again. It's really like a Charlie Brown and the football thing here. But the job of this commission is to ensure that San Franciscans are front and center in our commission process, and that aggregators like Spur, who have basically been campaign or lobbyists for policy and work within their membership to aggregate campaign contributions for elected officials. In the work I'm doing on the Prop J revisit, it's not really the developers that are the main contributors that are tied to projects. It's their consultants, their architects, their they're associated people that sit around from project to project. And that's what SPUR is. SPUR isn't really a developer lobbyist. It's this associated sector of the economy that makes their money off repeated projects. And that presence on the Planning Commission is really regulatory capture, where the agency that is going to be regulated by the Planning Commission has been captured, and then there's no ethical independence there. They're not serving one master. Ms. Johnson is serving SPUR, the developers, their consultants, their architects, and she's supposed to be serving as a citizen representative as well. I don't think we can have that. And for Commission counsel to recommend and say that's okay means that the Ethics Commission doesn't have ethically independent counsel if their counsel has to serve the city attorney who serves the mayor, who serves the planning department. So this is a really good case here for independent counsel on these matters for the Ethics Commission, so that not only does your counsel serve one master, we can be sure that we have independent advice so that our commissioners can also just serve one master. That's threading the needle of ethics all the way from soup to nuts. And in this city, with the pay-to-play culture going on, we need for this commission to step up and really be represented when it comes to Ms. Johnson. This will change inclusionary affordable policy moving forward so that neighborhoods like the one I live in the Mission will see a complete change in what our neighborhoods look like, even worse than we've seen in the past while. Attempts to mitigate here are being inhibited, so they're not even mitigating the problem that the Commission is enabling. It's a complete mess. Thank you.
Thank you. Any further public comment on matters appearing or not appearing on the agenda? If not, I'll recognize Commissioner Kopp for.
Mr. Chairman and fellow commissioners, I agree with Mr. Bush's comments and the supporting comments of other members of the public who've taken the time to give us the benefit of their effort and attention. And it is bothersome with respect to the issue, not the procedural issue respecting Commissioner Johnson of the Planning Commission, but the substantive issue about which I make no statement whatsoever, and it would be inappropriate for this commission to make any statement. But I note the record shows that Commissioner Johnson was announced last month as the executive director of SPUR San Francisco chapter. And the public record demonstrates some of the donation matters which have resulted in positions of opposition or support to various ballot measures in 2016 and probably before that. I strongly believe Commissioner Johnson should recuse herself from the item which is on the Planning Commission's agenda for Thursday, which is April 27, 2017. And therefore, I will make a motion that the Ethics Commission transmit a letter to Commissioner Johnson recommending and requesting that she recuse herself from any item dealing with the subject matter, which I will characterize as low-income housing, and others can probably refine it in a technically appropriate way.
Is there a second to the motion?
Second.
All right. Mr. Chen.
If I could interject just briefly on a procedural matter, this is not a matter that's agendized for tonight's meeting, and so I think it's outside the scope of the notice for Brown Act purposes. So I just want to note that for procedural purposes. I will say, however, that there's nothing about the Brown Act that prohibits an individual commissioner, like Commissioner Kopp, like yourself perhaps, who may want to separately and individually send a letter of communication to Commissioner Johnson.
That's noted for the record. In regard to the substance of what you're raising, though, Mr. Chen, it's been indicated that this is a matter that's coming up for vote rather soon, and it is something that is clearly within the purview of the Ethics Commission, something that the Ethics Commission should indeed speak to because of the importance of the ethical issue that's involved. So I think that I'm going to rule that Commissioner Kopp's motion is in order and that we should go forward with the discussion and the debate and vote on it. We have a motion and a second. Any further discussion by the members of the Commission? I just want to associate myself with Commissioner Kopp's remarks and his motion, and also associate myself with the fact that it is so germane to a number of things that have already been raised tonight by members of the public. With that, it seems that there's no further comment from the Commission. We'll take public comment.
Good evening, David Pilpel. A couple of thoughts. While I certainly agree with Commissioner Kopp's underlying concern here, I do give weight to the City Attorney's caution. This is not properly on the agenda, and I think, notwithstanding the timeliness concern, perhaps there's a way to craft findings that this came to the Commission's attention subsequent to the posting, and to defer this matter to the following meeting wouldn't be in the public, whatever the appropriate Brown Act and Sunshine findings are, so that you're in a good place to take this action. Absent that, I think there's a problem sending this communication from the full Commission. You certainly could do it as individuals. And the other caution that I would suggest is, because there could be a complaint or an investigation if Commissioner Johnson does not recuse herself. I'm not sure if the Commission is in a good place sending this kind of advance warning, even if it is coming from a good place, in as much as you may have to sit in the future to consider the merits of an investigation and enforcement action should that come out. So those are some real concerns that you may want to think about in the next couple of minutes as you decide whether and how to proceed on this. But again, I am certainly with the underlying concern. I think it is very well founded. Tough place. Thanks.
Is there any further public comment on this?
Yes,
yes,
on the case. I'm very much supportive of the Honorable Quentin Kopp's investigation of that, because double dipping is a new thing that's been going on in the city. After you finish them, go to OCII. Look at their executive director of public finances. All right, then go over to Housing Authority. Or the president of the commission is the deputy director of OEWD. So what that tells me, that Ed Lee don't have enough qualified people to be department heads. But I'm here speaking specifically dealing with the African American community. We are in a state of emergency, and the mayor got these people double dipping, double doing, and all of this other conspiracy, corruption in the Fillmore particularly. Yeah, I ain't got to mention it. Just read the papers. I'm looking at people I've been knowing for 15, 20 years. The FBI up here with the mayor. I've been knowing the mayor. Ask Ed Lee, he knows me. We worked together when he was with the HRC. And now he's the mayor. I can't get in to see him. Thank God he didn't want to see me. FBI, you know what? The paper said it was over 500 agents in that investigation from 2011 to what's going on right now. All that money spent. So when we finish this, we need to go down the list, because I'll be coming here and telling you what I see here at City Hall. I'm trying to tell y'all, and what I saw seems like it's against the law. And what I heard is so absurd. And the history is right in front of me. I've been here for 25 years. Most of y'all didn't know it. Yeah, I've been here 25 years through 3 administrations. I worked under Frank Jordan. He was a policeman. I was the first black in there with Jack Def, because they liked my show, Ace in Your Face. And from there, I evolved to where I am now. 63 years old, had a damn surgery because I've been dealing with all these department heads lying and flying for 25 years. And now they got double dipping, double dual. Y'all better check that. My name is Ace, damn it, and I'm on the case. I'm here to assist any way I can. I would bring you a list that needs to do that. Ed Lee, shame on you, man, because I ain't been able to see him. The police guard him like I'm a terrorist. Excuse me the way I'm looking right now, but here, I am not here to dress to impress. But I'm here to have some clarity in the way they do government here. I'm 63 years old. I've been around when Honorable Cop was the board of supervisors. Him and a couple other people were really doing what they're doing right now, checking government. I was just a young pup then, but now I'm 63, and I'm here to tell you what I done seen. You know, my family say, hey, Daddy, leave that alone. What is it getting you? You ain't got no salary, no staff, no nothing. But I'm here on Act of God, and right now we moving on. It's a new era. I ain't got no time for errors.
Thank you.
Speaking on behalf of Friends of Ethics, we certainly support a motion from the Commission going to the Planning Commission and specifically to Commissioner Johnson. I think that David Pilpel's suggestion of having a preamble that explains that this was an issue that arose since the last Ethics Commission meeting, that her appointment was announced, and the fact that the vote is coming up on Thursday was only noticed, I think, over the weekend, that it shouldn't be a prisoner of the calendar that keeps you from speaking out on behalf of the city's interest. It also would be an opportunity down the road when you take another review of conflict of interest policies of the city to deal a little more fully on the appearance of a conflict. Because if you go to the city attorney's good government guide, it's almost exclusively about a financial conflict where you have money coming into you. And since this is an indirect payment, according to Commissioner Johnson, it's a little problematic to make that claim off the top. But there's no problem in saying there's an appearance of conflict, that she's been retained to be an advocate. Her opinion is that there is no conflict as long as they do not directly lobby the commission. The fact that they have gone out publicly and made a recommendation on this issue, and that the mayor's office is saying that they want her to be able to vote because it's impactful to the administration, suggests, and since she is the swing vote on this, that the outcome has been baked into the process outside of the public view. What you were doing would be bringing this to greater public view. Thank you.
Yes, Commissioners, Mark Solomon. You know, the worst that could happen here with a resolution urging Ms. Johnson to do something is that somebody could go to court, make a stink, draw more attention to it, and possibly get your resolution urging that there not be corruption thrown out by court. I doubt that's going to really happen. There's no real stakes here. You guys have to come out and take the minor risk, take the stand for the right thing, and let that stand for itself. Thank you.
Thank you.
Chair Keene, if I
Director
might.
Pellin.
Yeah, I'd like to make a suggestion. I do believe the Commission needs to be able to express its views as issues come up. I would also encourage the Commission, though, to think seriously about taking a formal action when it has not been agendized. I think that's a process that probably is not an optimal one for the Commission to engage in. An alternative approach would be with the Commission's viewpoints that have been expressed this evening. Certainly, your staff, we could work with you, Chair Keene, to communicate whatever you think reflects the Commission's comments this evening and have a letter to that effect sent to the Commissioner to raise whatever questions or points that you'd like to. But I think that may be one way of achieving it without compromising the Commission's commitment to open government processes, which we do believe are important, of course. So I would just offer that as an alternative approach to achieving the same end.
Mr. Chairman, let me reiterate and make it clear. My motion is to transmit a letter from the Commission signed by the Chairman of the Commission. And I have no view as to who should participate in the letter, but I would offer my time and attention to the wording of the letter. It is not a motion for a resolution. It's a simple letter. And then I'll have a couple other points to make, or maybe I'll make it now since it'll save some time. I'm not clear from the reports as to whether the city attorney's opinion was written. Do you know through the chair, Mr. Shen, if it was written?
So I think I'm not in a position at this meeting to discuss the advice that I may or may not have given to another city commissioner.
And why is that?
Because I respect the attorney-client privilege and the confidentiality advice I provide to other city officials,
I want those,
like I would do for any of you that I advise.
I want those remarks enshrined someplace tonight because I will be making a consequent motion. I would also like, after this is disposed of, a letter sent from the commission to the city attorney, Mr. Herrera, asking whether that advice was written. If so, a copy of the written advice.
Is that in the form of a motion?
Well, I think we have to dispose of the pending motion, and then I will make it.
Let's work on the pending motion and a couple of other things. Commissioner Kopp, would you, in terms of the comments that have been made, would you accept as a friendly amendment to your motion that in the letter that I would write, I would sign, which would be drafted by you and Director Pellin, that we would have a preamble, as was suggested.
Yes.
The effect that we're doing this, we understand that this is an extraordinary matter, extraordinary thing that we're doing, and we're doing it because of the expediency that's necessary to get it, because since we don't have time to agendize it, when the substantive matter is coming up for vote by the commission and by the city and county of San Francisco before we'd have a chance to really agendize this.
Yes.
Okay, so we'll have that. That then would be the motion with the friendly amendment, and with the second, did you accept that?
Second.
Okay, and that would be the motion at this point. Is there any further public comment or comment by commissioners in regard to the action we're about to take? Okay. All those in favor of the motion say aye. Aye. All those opposed? The motion carries unanimously. So Commissioner Kopp, you'll work with Director Pelham on that, and I'll be happy to sign the letter.
And I'll make the second motion referred to, which is that a letter be sent by the chairman of the commission on behalf of the commission, asking the city attorney if the relevant opinion to the planning commission commissioner is written, and if so, for a copy of that advice.
Is there a second to that motion? I'll second the motion. I think if we have a written opinion on that matter, since it's a matter of such substantially importance in regard to an ethical question by a commissioner in the Planning Commission and something having to do with city business, if there is something that this commission, as an ethics commission, should know that indicates that that is okay, and I think that's, as we've seen in our vote on the previous message, we have strong feelings that's not okay. If we can be corrected by that by a written city attorney's opinion, if there is a written city attorney's opinion on it, I think we should have it so that our knowledge should be increased as to whether or not we're doing something that we shouldn't do, and as to if we are doing something that we shouldn't do, why it is we shouldn't be doing it. So I think this commission, as the Ethics Commission of the City and County of San Francisco, should be apprised of the city attorney's opinion in regard to the fact that Commissioner Johnson could be going ahead and doing this and voting in this way, and that there is no ethical problem with it. That's something that we definitely should know about, because obviously if there's a contrary opinion, we should know why we're wrong. So I'll second it. Commissioner Rennie.
The difficulty I have with the motion is that the attorney-client privilege is not solely with the city attorney, but it's also with either the commission that asked for it or the individual commissioner. And absent a waiver by both, I don't think the city attorney is in a position to deliver it to us. Now, it may be they'd be happy to give it to us, but we as a commission have jealously taken the position that attorney-client privilege applies to us and that the city attorney can't waive it if we don't waive it. And I think that probably would apply to whatever information or instructions or advice that the city attorney gave either to Ms. Johnson and or the Planning Commission.
Well, perhaps, Commissioner Rennie raises an important point. Perhaps, Commissioner Kopp, what we could do is urge the city attorney. Commissioner Rennie suggested it might be a situation where the city attorney, on reflection, might be happy to give it to us. We should urge the city attorney to consider whether they want to give it to us, and that we would, and tell them that we would like to have it, and urge them to give it to us in light of the fact that it would be quite helpful and necessary to us in carrying out our functions if we're carrying out our functions in some incorrect manner. Commissioner Kopp, would that?
I would, the idea is worthy, and I would expand the idea. And in doing so, I will save us time later to make it clear what I intend to do. The city attorney serves the people of the city and county of San Francisco, as well as the Ethics Commission and the Planning Commission, the members of the Planning Commission. To me, the people of the city and county of San Francisco are preeminent and rate higher than any commission of the city and county of San Francisco. And this discussion highlights what I intend to do, and that is make a motion for this commission to formulate a simple charter amendment which removes from the law the provision that the city attorney is the attorney for the Ethics Commission, and enable the law to state that the Ethics Commission shall have the power to retain its own counsel. I've had experience with transactions like this as a civil grand jury judge with county counsel representing various districts, special districts, school districts in San Mateo County, one of which was the subject of a grand jury investigation for violations of the Brown Act and a consequent report. It took me a year and a half to obtain a change in procedure so that county counsel no longer sat with the grand jury through all of its deliberations. A similar episode occurred in Santa Clara County about 15 years ago with county counsel, and the civil grand jury engaged its own attorney. There is a conflict of interest which cannot be cured with a city attorney under San Francisco law representing every commissioner, representing every commission, representing every employee who's accused of a violation of one of the laws for which we have responsibility as the Ethics Commission. I would add to the letter, Mr. Chairman, which you have outlined, a request that the city attorney act immediately before Thursday, April 27th, to obtain the consent of his client, Commissioner Johnson of the Planning Commission, for publication of any written opinion.
Okay, so let's understand exactly what your motion is, Commissioner Kopp. I think I understand it, but that we are urging the city attorney to reconsider, and to consider whether or not they would inform us of whether or not there is a written opinion and what the written opinion is. And if they feel that there is some sort of impediment to that, we are asking them to request of their client,
right,
whether or not the client, in this case, Ms. Johnson, I guess, whether or not the client will consent to waiver of the attorney-client privilege so that we can obtain that report.
And the public can
yeah,
obtain
sure.
it.
Well, we as a repository.
And I'd add this footnote, which maybe should be included in the letter. I don't think the fact of whether the opinion was written or not written is a part of any claimed attorney-client relationship.
Okay. We've got a number of things on the that have been talked about, but as I see the matter before us for a vote, it's whether or not Commissioner Kopp's motion to urge the city attorney to consider telling us whether or not there is a written opinion, and if so, allowing us to have it. And if the city attorney feels that they cannot do that because of the attorney-client privilege, to ask the city attorney to consult with the client as to whether or not the client will waive that privilege so that we can indeed get that advice. That's the substance of the matter before Commissioner Chu.
Chair Keene, I have a question for City Attorney Shen. In the falling short of sharing any advice, whether written or oral or summarizing, and is there any other way, to my fellow commissioners' comments prior, for the city attorney to enlighten us in terms of where we may be interpreting these ethics rules, incorrectly, and that that you could elucidate some of the points of law that we may not have honed in on?
Yes, there's certainly ways that I could speak to you about conflict of interest laws, ethics laws, and so forth within the jurisdiction of the Ethics Commission. We can have that discussion at a future meeting, subject to proper noticing. But certainly we can engage those general policy discussions. That's why I'm here at these meetings, to help aid those discussions. But I think the best arena for that to occur, the best forum for that to occur, is that, again, at a future meeting, subject to proper noticing.
Understood, but given the urgency and the short time frame of the upcoming meeting on Thursday, is there anything that can be done between now and Thursday morning that could help educate us in this regard?
Right. So subject to the Brown Act and the Sunshine Ordinance, what certainly I could do and make myself available for are individual discussions with members of the Commission or the Commission staff about some of the concerns that have been raised by the Commission itself and the public. I can have those individual discussions with any of you to the extent you want to discuss them before Thursday.
I don't know, but Commissioner Kopp, I don't quite understand. We've made the decision to advise Ms. Johnson that she should recuse herself. If she chooses not to, that's a decision she can make. But what difference does it make to that advice at this stage as to what the city attorney may have advised her or may not have advised her, and may advise her once the letter goes out to her telling her she should recuse herself, and she obviously may want to talk to the city attorney, whoever it is representing the commission, to get advice as to whether she ought to follow our instructions. But I don't see what difference it makes what it was the city attorney told her. We've made the decision, regardless of whether the city attorney told her it was right or wrong. We've made the decision to tell her she shouldn't sit on this matter.
May I
Yes,
respond?
Commissioner Kopp, sorry.
Through the chair to Commissioner Rennie, it makes a difference to the public. It makes a difference to the commission, this commission. It makes a difference to me. There's a difference between a written opinion in which an attorney sets forth in writing the rationale, including citation of case law, for that opinion, and an oral opinion, which can, as you know, and we all know on this panel, can be a conversation in somebody's law office or somebody's office, in this case, at Spur. I don't believe the simple fact of whether an opinion from a public attorney is written or not written. If it's not written, it's oral, is subject to the attorney-client privilege. The content of that opinion is subject, perhaps it can be argued, under the state of the law in San Francisco, including the law establishing this commission. But the fact of whether it exists is not a part of a confidential communication between attorney and client sufficient to thwart the public, which has an abiding interest in it. As you can tell from the testimony, people like Mr. Solomon and others who testified, this is a vigorously contested issue, this whole subject of affordable housing and any development of land which occurs in San Francisco. And I want to know further just how the city attorney operates with respect to other commission and other commission's members, because it certainly will be pertinent to what I have announced I intend to introduce with respect to this commission having its own attorney with allegiance to this commission and the public this commission works for.
Commissioner Kopp and Commissioner Rennie, I've been listening to both of you, and you both make persuasive points in regard to a number of things. As the chair, I would just make a suggestion to Commissioner Kopp that sort of partially goes along with what Commissioner Rennie is raising, and that is we have the letter going out relating to our feelings relating to Ms. Johnson. It's a unanimous statement of this commission, and I think that's very important. I think the questions that you're raising relating to whether or not we are proceeding correctly, that there's some knowledge that the city attorney has that would change our minds about the tack that we've taken, whether or not a city attorney's opinion has been issued, and whether or not we can see it. Those are all important, but they don't have the crucial aspect of the vote coming up that Ms. Johnson is about to take part in. So I would suggest, Commissioner Kopp, with all due respect, if we can, to take what Commissioner Rennie has said, and that we agendize for our next meeting a full discussion of this matter and all of the ethical aspects relating to it, whether or not we have done the right thing in regard to, substantively in regard to what we state in the letter, and also learn whatever information that the city attorney contends that it has that might enlighten us about whether or not we should be proceeding the way we're proceeding. I think we'd be better off doing it that way rather than taking a vote on the motion and it looks like we're not going to be unanimous, we're probably going to be split. So I kind of respectfully request you consider withdrawing your motion, and we go ahead at the end of the agenda and talk about calendaring all of these things that we've been talking about for a full discussion next time.
I accept that suggestion, Mr. Chairman, and I also note that I will have a letter to the city attorney tomorrow individually asking if it is in writing, and I will predict that it is not a written opinion. It's some deputy sitting down with the Planning Commission commissioner and saying, oh, it's okay to participate. And that well may be the state of the law, which means that such circumstance must be added to the Prop J material and the other items that I advanced last month.
Okay, Commissioner Kopp, I appreciate your taking my suggestion, and you have raised very important points, which we'll have for full discussion next time. I think, Commissioner Chu, did you have a comment on it?
No.
Oh, okay. So we'll hear public comment now.
I'd like to make a public comment.
Right.
On a couple of things. At this point, we do not really know that there was ever any city attorney's opinion, oral or otherwise. All we know is that Ms. Johnson says there was one. Mr. Shen here did not confirm that there was such an opinion. And in fact, Mr. Shen is the one who is in the emails from the mayor's office as being involved in the discussion. But he doesn't say that there was actually an opinion. Secondly, if you take a look at the commission here's own policies, when someone is seeking an opinion on whether they can behave a certain way on campaign finance, they are told that the only protection you have if an objection comes up is if you have an opinion from us in writing. That's the same standard that you're asking for the city attorney to take, that there should be an opinion in writing. The third point is this raises a serious issue of a firewall between different parts of the city and how they are advised. This is not the first time it's come up, and it comes up for very good reasons. But it certainly has, in this case, as a consequential issue, because it will affect what gets built in the city and who gets to live here for the next 20 years. We're talking about a policy that puts on the low end the affordable housing set aside that would be affordable to school teachers, restaurant workers, hotel people, the people who make this city run, who make a big difference to the economy of the city, versus the amount of profit that goes to the developers. And we know that the developers are the ones who are essentially paying for much of what Spur's work is. And if you look at Spur's IRS filings, their budget is about $6.8 million. And if you look at what they're doing politically, they may call themselves a think tank, but they spent $150-some thousand on campaigns in the last 24 months. In addition, Ms. Johnson was a member of the board of Spur when this policy was adopted. And when the policy was issued in February, she was in negotiations with the city's attorney's office on whether or not she had a conflict of interest. So at a minimum, I think that Commissioner Kopp's suggestion that you request from the city attorney, was there an opinion, and is the opinion in writing, is well within the bounds of what would be allowed. And that's my opinion.
Thank you.
And when you say board, you mean the board of Spur?
Yes, I
Is
do.
that right? Okay.
Do we have any further public comment?
This is very educational to me and very informative, I'm sure, to be for my. So I'm getting ready to start my own television network. But it's very interesting because, without this commission and the leadership of the Honorable Crop, we wouldn't even think about this. This type of thing in City Hall, it's been going on for years. Pay to play. I mean, you could name the situations. There needs to be a commission like this and doing what they do. And I'm going to leave now because I got enough material I could go back and study it, and I'm going to research mine. Because I know Christina, and I don't know what the issue are, but it's so parroted that this happens all over in all these commissions. It happens every day under this administration, which I'm not scared to say it is the outreach of Willie Brown's commission. See, the thing about it is, if y'all don't stop what's going on right now, the pay to play is the eyeballs, the FBI is here. But if y'all don't stop that, what's going on inside the commission right now, this is going to be inherited on and on. Look at all these young people here. These guys, these are young people here. Cop, I'm 20 years younger, but these are young people. These are young. The City Hall, all of the commissioners, the chief of staffs, and department heads, they're all retiring for whatever reason. Is it because of the corruption or getting old or whatever the case is the turn of the leadership of the surface. So all I have to deliver to the city and county, which I've been under the scopes for 20-some years, being the outsider, so therefore I don't get no credit, no nothing. They just look at me and document whatever. So I've been doing the same thing for 20 years. Most people say, oh, Ace ain't got no video, no tape in there. But I got so much videotape and history, I don't have to take another picture. I don't even have to come here. All I got to do is just write the stories, and it'll relate to what's going on right now. Like I mentioned, the Honorable Cop, back in those days, he was doing that, and others was trying to find out what the corruption was going on in their own way. And these are lawyers, judges, they know what's happening, and now they're coming back to help our communities. So I don't give a darn what the city attorneys say and all that. Investigation coming from that way and coming from this way, and when we come together and show it, then Trump could come to Fillmore and tweet on all the things we done missed in the Fillmore. I'm really sick and tired, I'm close, with the Democrats. See, I'm a nonpartisan, but I did vote Democrats. But what I do agree with Trump, what have they done for us? This city's ran by Democrats for the longest, and all of it has been doing the same thing over and over. There's been no accountability. But now we have the Ethics Commission, and soon this will be turning over against the new. But this is something that you'll be seeing me. You only hear once a month. But in that month's time, when I come back, it's going to be coinciding. I'm going to say, oh, this is what we need to do. And Ed Lee, he knows me.
Thank you.
David Pilpel again. I reiterate my caution about the Brown Act and noticing I think we're a bit afield for all these reasons from public comment. And if someone brought a sunshine complaint about this sort of conduct at any other board or commission, you would likely have to hear it on the merits. And yep, here we are. Nevertheless, there are a lot of issues that were raised, and I want to address them very briefly as best I can. At a minimum, I think the letter that you agreed to send, if that does happen in the next few days, that should be attached to the summary of actions that you normally issue a day or two after the meeting. And that letter should be posted on your website so that everyone can see it, and not just Commissioner Johnson, presumably. Whether or not there was an opinion issued by the city attorney in writing or orally, I think there are a lot of issues implicated here, and you could certainly request that they create or craft a public opinion that addresses conflict of interest in this kind of circumstance, because it could occur elsewhere in the city, and there are some current guiding principles, some of which may be obvious, others less so, about how to parse this situation, and that may be instructive for you and for the public in the manner of a public opinion that the city attorney can render and post and make available. It was perhaps alluded to, but the city attorney actually has screens set up for due process, for ethics, and for, I guess, other kinds of circumstances that arise that I'm aware of, that most people aren't aware of, and having some understanding about how the office does screen off individuals and how advice is given in these kinds of cases may also be helpful. And I don't know, I'm aware of some of that, but I don't know that it's all well documented. And in addition, the city attorney's website already has at least 3 opinions that I've read that address. One addresses the role of the city attorney broadly in terms of giving of advice to various actors in city government, the attorney-client privilege and who holds the privilege and how that should be held and how it's waived and items disseminated. And the third is how public opinions are crafted and made available on the website and certain standards and all of that. And just finally, the documents that Larry Bush submitted, I'm interested in getting a copy, so perhaps I can get that from the office tomorrow. But there really are a lot of important issues here, and you should have a thoughtful process to delve through it, as you suggested you'll talk about later, with the city attorney, whether you agree with their advice or not, so that this information is made public and we can all benefit from whatever analysis and advice has been given, if any has been. Thanks.
Thank you. Okay, there being no further public comment, we'll then move on to agenda item 3, discussion and possible action on the draft minutes for the Commission's March 27th regular meeting. Are there any comments or corrections to the minutes?
I just have one on page 9 under discussion, possible action on items for future meetings. Go down 5 lines. I did not say that conflict of interest prohibitions exist to prevent occurrences such as a member of the Planning Commission also being a member of SPUR. I said also being executive director of SPUR San Francisco chapter.
Okay, we'll have that correction.
I'd like that corrected.
Any further comments or corrections, Commissioner Rennie?
On page 9, about the middle of the page, where it's quoting me, it says Commissioner Rennie asked a clarifying question. Status of continuation, it should be show cause, not no cause. And and Director Pelham stated it should be show cause, not no cause.
Okay, that'll be corrected. Further corrections or comments? Mr. Popo.
Thank you. I went through with my usual fine-tooth comb and have some non-substantive edits that I'll offer. If appropriate, they can be incorporated. Thank you very much.
Thank you, Mr. Popo. Okay, we'll now move to...
Move approval of the minutes.
Oh, I'm sorry, yeah.
Second.
Thank you. All right. All those in favor of approving the minutes as amended, say aye.
Aye.
Those opposed? The minutes are approved. We'll now go on to agenda item 4, continued discussion and possible action on Commissioner Keene's campaign finance and ethics proposal introduced at the March 27th, 2017 meeting. And Executive Director Pelham.
Thanks, Chair Keene. We have in your packets and online for the public and here in the room, agenda item 4, a memo by our new senior policy analyst, Kyle Kundert. I'm delighted to introduce you to him this evening. He had a first day on April the 10th, and your memo is the 19th. So he's here to provide an overview of the memo so that everybody in the audience has a chance to hear some of the basic research, hear from us about summaries of next steps that we would be proposing. So I just wanted to introduce Kyle to you and to the members of the public who are here this evening and turn over the item to him to walk us through.
Very good. Thank you.
Hi, good evening here. I'm trying to just find do we have a clicker? No? Okay. So I have a little PowerPoint here. Hopefully you guys can see that on your screens. Yes? Okay. So I will walk us through this. But good evening, commissioners, members of the public. As stated, I'm the senior policy analyst, Kyle Kundert. I'm here today to talk about or continue the discussion on the revised Proposition J, which was spoken about and public comment was had at the last commission meeting. So at that last meeting on March 27, 2017, Commission Chair Keene introduced the proposed revisions to San Francisco's campaign finance reform ordinance, known as CFRO, designed to restore the November 2000 voter initiative, commonly referred to as Proposition J, in a revised form. That proposition seeks to eliminate corruption in the city by prohibiting officials from accepting personal and campaign advantage from persons who had or were about to receive a public benefit. What follows is staff's initial research to date and the next steps regarding that revised Proposition J and the larger review of CFRO. So let me begin. So just some introductory remarks and a little bit of background. Again, hopefully everyone can see this, but we will provide this PowerPoint online tomorrow for individuals with this presentation, since we did not provide it beforehand. So Proposition J was in California was part of a larger project called the Oaks Project, which was sort of proposed by the Foundation for Taxpayer and Consumer Rights in 2000 and 2001. These initiatives appeared on the ballots of 5 California cities, if I'm remembering correctly, in 2000 and 2001. The project's sort of main goals here, summarizing, were to reduce conflicts of interest, limit the corrupting influence of gifts, contributions, emoluments, etc., and to limit public funds being expended via partiality or bias. That initiative was passed in some form in all 5 of those cities. Now, two of those cities, the city of Vista and San Francisco, would very quickly sort of overwrite those laws with other conflict of interest of laws. But I do want to point out that despite some protracted legal battles in some of the other cities of California, they all were instituted in some form. That is just a little background on this initiative before we move on forward to the revised proposition. So the revised Proposition J, as currently drafted, and again, the attachments to this that we'll be citing to in the memo begin on page 14. We didn't add a table of contents to this item, but those attachments begin on page 14 for those individuals following along in Agenda Item 4. And as a note here yet, just this summary here, or this PowerPoint, is meant to be a summary of the laws, certainly not an exhaustive list of items at the memorandum notes. I would refer to you and the members of the public to the memorandum. This is a summary of the major items that staff has highlighted. So the revised Prop J is currently drafted. A few of those large items. It broadens the scope of officials covered and public benefits encompassed. The stated goal in the findings and declarations in the proposed draft of Proposition J, which the individuals have and which is attached, is to sort of extend and strengthen the goals of the original Proposition J into a revised version to reduce as much as is possible sort of the corrupting influences of money generally. So the revised proposition seeks to close those loopholes and, again, generally prohibits officials from receiving those personal or campaign advantages. It additionally bans fundraising by certain high-ranking public officials for elected officials. That would be board members, commissioners, and department heads. It adds additional enforcement mechanisms, including debarment, citizen suits, an expanded prohibition period for members that or individuals or persons that are receiving a public benefit. It also adds reintroduces an inter-candidate ban, transfer ban, and requires development of a database to track public benefit recipients. The next portion here, following along generally with our memorandum as well. So staff has analyzed myself and Deputy Director Bloom with a number of other individuals have addressed in our research or come across a number of legal contexts and considerations for the Commission to consider at a future date when it revises, works with interested parties in revising the proposition and ensuring that it sort of meets the constitutional and legal standards that are going to be required. The first of those is just the First Amendment issues. As we know, the campaign, the sort of the framework of campaign finance law in the context of the First Amendment, particularly since Citizens United has changed. That's noted in the memorandum, and sort of the items that the Supreme Court, as well as the lower courts, have sort of stated that we can limit in the campaign finance sense, which is ultimately the First Amendment sense, is sort of been narrowing particularly since Citizens United. So the question that we have to address as staff and with interested parties is what can we legally limit as far as contribution bans go, and when. So we need to, and part of our ongoing research is to figure out what those are and how we go about doing that. We can't sort of just invoke a claim that all these things are going to pass constitutional muster. Part of our goal here in revising these things is sort of to create or establish facts and a record that will be supported and will allow us to pass any constitutional muster that we must. Additionally, or along with that point, is there was concerns raised by other jurisdictions. I was hoping to have some of the materials from the case in City v. Vista v. Drake. That is, the City of Vista was one of the cities who passed the initiative early on, and they actually overrode it almost instantly with another initiative. But they did file suit to attempt to keep the original Proposition J off the ballot. In that, they addressed some of the constitutional concerns. I have yet to see, or we as a staff have yet to see the arguments made in that case, and there were amicus briefs filed, but we would like to get that to ensure that we're addressing those legal arguments that were made in that original case. And then jumping down, another consideration that we have to take on is the, as I said earlier, is the provisions of the civil penalties or what has been called the civilian suit. There is a provision in the Political Reform Act that allows the civil penalties, civil suits to be had, and for people to collect 50% of those actions. But we have to sort of address under the context of the Eighth Amendment. Some of the excessive fine clause issues that may be had under the Eighth Amendment here. Jumping over to more due process and administrative procedures considerations, there was, and speaking with Oliver Luby, who is noted in the memorandum, we did speak with him, and we were noted that the definition of public benefits extends all the way to entitlements. We have to address whether we can refine and clarify entitlements to ensure that we're not extending these things to sort of recipients of public welfare or lower income, things that may be receiving a public benefit under the law that would restrict them then from giving. So we're trying to evaluate that provision and whether we can either clarify that definition or remove it from the law potentially, but hopefully we can clarify that to ensure that it meets a legal standard. Sort of our last legal consideration here, at least noted here, is the debarment proceedings. Debarment generally is just being excluded from, enjoying the rights or privileges, of a public benefit. So this is a provision that was based on the City of Los Angeles's Ethics Commission law. So we just want to work with individuals to make sure that we incorporate the debarment proceedings with the appropriate due process requirements, and we do have a question out to the city attorney's office regarding that, whether and how we can enforce that provision. And so, moving on here, sort of to the last slide before we just get to some procedural items moving forward. As we have said, we are looking to harmonize the approaches in this revision of Prop J with a larger review of CFRO. That is, how can we strengthen and continue to improve the enforcement mechanisms of CFRO with revised Proposition J and some of the other campaign finance issues, just seeking to sort of extend and expand the strength of the campaign finance laws in the city and county of San Francisco, just to ensure that we're reducing as much as possible those corrupting influences and conflicts of interest. Taking these into effect are larger considerations, not just about the revised Proposition J, but about CFRO review generally, is staff is looking to sort of as a policy matter. We always are going to evaluate the legal constraints that we see and present those. We also have to evaluate the administrative responsibilities. As you know, many of these things don't just involve the Ethics Commission. They involve the Controller's Office, they involve the City Attorney's Office, and they may involve a number of other players that we certainly will want to bring them in discussions to ensure that we have a cohesive plan to bring any revisions of CFRO forward. Next is implementation, again, hitting on duties, costs, and a time frame. We want to bring in interested parties and players, understand who has what duties and the costs associated with those. And again, redundant and contradictory provisions is always something you evaluate sort of in statutory interpretation generally, or just a matter of redrafting statutory or ordinential provisions in this case. And lastly, just Political Reform Act conformity. We have a sort of hierarchy of laws, and we have to ensure that anything that we do propose as a revision that goes forward complies or conforms substantially to the Political Reforms Act's ideals. And just finally, our policy development strategy going forward. We generally want to work with the interested parties to create a strong, effective, and enforceable provision that fits within the larger goal of revising or reviewing CFRO. We want to hold interested persons meetings, which we will get to in the next slide. We want to draft and make available for review public thoughts and concerns with the project. We'd like to draft and make available for review memorandums outlining the concerns, goals, and project plan. And we want to research and draft a strategy for implementation once we have presented these items to you as a way to sort of move forward and keep us on track. All right, so summarizing here again for individuals, we do plan to have 2 interested persons meetings, both at our office at 25 Van Ness on May 9th and May 11th. One will be at 5:30 p.m. on May 9th, and the other will be on May 11th at noon to hopefully incorporate everyone's schedules to show up for interested persons. Then generally there's just a timeline to circulate, but I will let individuals read those when we post these tomorrow. So our last item here is I want to open it up for questions, comments, concerns for the commissioners just regarding what you'd like us to address at those interested persons meetings regarding questions or concerns going forward, and generally if you have questions or concerns about this memorandum.
Yes. First, I want to compliment you and the other people who've worked on this. It's an excellent analysis of what we talked about last time, and an excellent analysis of the proposed revised Prop J. You've done a great work on the history and the things that have been seen as problems in other jurisdictions and the things that have been raised as potential pitfalls. I think one of the things that's clearly illuminated in terms of the history that you lay out is that in regard to what the essential thing that Prop J did and that this revised Prop J does, there is no constitutional question about it, because even under Citizens United, with Citizens United and all of the cases that the U.S. Supreme Court has done recently or within the last generation, narrowing the ability to regulate campaign contributions or contributions relating to public officials, none of that is involved in Prop J, because the essential element of Buckley versus Vallejo, which was the first case having to do with this, was that the court says that we can regulate and regulate substantially any kind of payments by people to actual public officials. in terms of either campaign financing, campaign contributions, or anything else, because there's the quid pro quo aspect of it. So the quid pro quo aspect in terms of someone giving something to a public official who has provided something to that person, to the person who's actually making the contribution, giving something directly in terms of a personal benefit or any of the things that we've talked about, those are fine, and we can do that. We just can't limit political speech in terms of someone who wants to spend money on something. But we can regulate and prevent that person from giving it directly to that benefit directly to the public official who's involved. So that's and all of much of the litigation, as I see, that's taken place in the early part of this century that said, well, there's some constitutional questions, had really not recognized that essential aspect of Buckley versus Vallejo that says you can do exactly what we're doing here. So I think you did a great job on that. And I look forward to you going forward with writing the ultimate Prop J revision that we're seeking with all of the language that we had in it. In regard to the other matters that you raised, the tangential matters relating to things like debarment and other types of things that might duplicate other things like in CFRU and where we might want to tighten things up, those are going to be welcome. But I look forward to the interesting persons meetings, and I think you've done a fine job. And hopefully, when we come next time, we'll have the actual language of the Prop J ordinance that we desire. We talked about last time that we can vote on it.
Thank you, Chair.
Commissioner.
No, I'm fine.
I was going to say, also, I joined with Commissioner Keene on complimenting you on the thorough analysis. But he had just said they were counting on you to come at the next meeting with the draft, and as I read the timetable, you are saying you're going to come to us at the June meeting. Is that correct?
We'd like to have final revisions at the June meeting. Yes,
That's fine. I don't mean in any way to rush you on this. This is a big job, and as was pointed out by Commissioner Rennie last time, I was originally given this task, and with my usual speed, it took me a year and a half to bring it. So,
try to be a little quicker than that. Yeah.
Thank you.
Thank you.
I'd like to join my fellow commissioners in commending you, Kyle, on this really excellent work. It was very helpful and very concise in laying out the constitutional issues as well as the substantive issues and the procedural issues. And my only observations would be, please take all due care and time to do the analysis to make sure that it is narrowly drafted in a way that will pass constitutional muster, because I don't think any of us would want to, put something forth that will be struck down. And that, to me, what was very important would be to harmonize with the existing CFRO laws and conflicts of interest, so that we're not creating more confusion in our attempts to create a better Prop J. And then lastly, I think that resources and the actual practicalities of implementation can either doom or propel any measure to success. And so I think having a very clear understanding of what is going to be required for both on our end at the Ethics Commission as well as at the controller's side in order to be able to make something operational, and that when we go out of the gate and we can turn it on at that time, that it will be successful, because it would be a real shame if we were to do all of this work to design but fall down on the implementation side. And it's not just up to us, at this point, and that I'm sure we'll get to it as part of the budgeting process. But all of these matters will take resources, and so I asked Leanne to think about how do we pay for this, and it's not to stop us, but also just to be clear in terms of what it is that we are setting out to do and what it's going to require to be successful.
We'll take public comment on the matter then if there are no further comments by members of the commission.
Thank you.
Commissioners, Larry Bush from Friends of Ethics. We were very impressed with the quality of analysis that has just been presented. It is a sea change, but the kind of sea change we've been seeing a lot of from this commission and as new executive director. There are just a few points that we would like to suggest be given some consideration. The report does a good job of looking at those cities that passed the Oaks Project versions a few years ago, but there are other cities that have undertaken efforts to address the same issues. One of those is the city of Richmond, which was, at that time, has its deputy city attorney, Randy Riddle, who used to be the city attorney who actually wrote the charter for the Ethics Commission. So we can make a copy available of the draft that was done for the city of Richmond. I don't know what other cities are involved, but in addition to California, of course, there are other cities that have examined the same issue. On the issue of debarment, I'd just like to suggest one way that we might look at handling that is to write into city contracts, as we do now, a prohibition on contributions, a statement that says, in addition to other penalties, that one penalty could be debarment, and that might reach the issue of adequate notice. I'd like to encourage a very robust outreach for the IP meeting. In the past, groups like unions have not been included, except as an afterthought. And I'm confident that this commission will do better, but I think this is a very urgent issue. And I would just point out that in general, this comes at the same time that we've just seen indictments handed down by the FBI in 8 cases, some of whom involve San Francisco businesses with San Francisco contracts. The indictments are for bid rigging and bribery, and that while those indictments are pending, the trial is ahead. At the same time, the record at the Comptroller's Office shows that hundreds of thousands of dollars are still being paid to those people who have just been indicted under current city contracts. I know it's legally difficult to go back and revisit a contract, but it's another reason why you would want to make sure that when something has gone wrong and has been found sufficiently wrong to result in legal action by enforcement people, that we're able to not just stand on the sidelines. Thank you.
Thank you.
Good evening, Commissioners. I'm Debbie Lerman. I'm with the San Francisco Human Services Network, an association of about 80 health and human service nonprofits, most of which contract with the City and County of San Francisco. I realize fully that some of you folks have had years of thinking about Prop J and what is still in effect and what is not still in effect, and that many of you are deeply steeped in ethics issues on a regular basis. And these are truly honorable goals. Having said that, our first look at this was in the last 72 hours. And what we see is a 50-page packet of dense legalese with a piece of legislation over 20 pages long. And I'll be honest, I am confused, it's complicated, and it's overwhelming to me on first look. And I'm a person who deals with legislative issues on a regular basis. I can't speak for the general public here. But there are significant potential far-reaching impacts in this legislation for constitutional questions, for First Amendment, for advocacy. And I, frankly, do not yet even come close to understanding how this will affect other recent gifts and behests legislation that's been passed, as well as campaign contribution stuff. There has not been, to my knowledge, a detailed hearing at this body of what this ordinance would do. And I don't know what's in there for potential gotcha clauses or to put it more succinctly, or better, unforeseen consequences that people haven't thought about yet. So I am here today solely to talk about the process, not the content. Prop T was a success because we had extensive opportunities for review. We had several interested persons meetings over an extended period of time and lots of time for written comments. And I'm a little distressed. I heard some of last month's meeting where there were rushes to just approve this right away and move it onto the board before any extensive kind of public hearing. And I'm so relieved that there will be IP meetings, but I believe it is, I don't understand why there is such a rush. If the board isn't going to take this up to the fall, if there's no election until June of 2018, then why does this have to be pushed through by May or June? Why is there a written comment deadline for the day after the interested persons meetings, which is going to be the first opportunity for a detailed review of this ordinance? How the heck are we going to sit down and collect our thoughts and get that into writing and share that with our constituents and other stakeholders and put together a well-reasoned piece of public comment? I would suggest stretching this out at least another month through July, scheduling more IP meetings at each stage of the process and longer deadlines for written comments, and ask you to please consider that. I think it will be a better process and better legislation for the Board of Supervisors if we can work together as we did with Prop T. Thank you.
Thank you.
Good afternoon, Commissioners. My name is Fernando Martí with the Council of Community Housing Organizations. Similar to HSN, we are a coalition that represents 24 affordable housing developers and community advocates on a number of issues. And so, of course, we're very much interested in this legislation. Commend you for moving this forward. Like Debbie Lerman said, I think that we are much more interested in raising the issue of process and how much time we actually have to look at this legislation, read it carefully, and be able to provide you with our understanding of this. I think that on page 12, you have the timeline that you are looking for this. As you can see, there's a total of 19 days from now until the time when public comment, written comment, is due. As Debbie said, that deadline is the day after that interested persons meeting. The way that large coalitions of groups work is that we would come to an IP, receive comments, hear, ask questions, and then be able to gather our folks together to discuss if there are any issues that are of concern and be able to write something that we can bring back to you, preferably in a written form in that written comment section. So as Debbie said, I think part of what we would want to see is some more time ahead of time between the IP and the time when written comments are due. And again, as was mentioned before, the Board of Supervisors, because of their recess, are not likely to take this up until the fall. And so I guess we wonder why there is such a rush to move something forward. If not June, perhaps July might be the time when you're looking for a final vote to move something to the Board of Supervisors. They will probably not be back in session. I think they take August off. They wouldn't be back in session until September anyway, so you have some time to be able to get succinct public comment on this. Thank you very much.
Thank you.
Good evening, Commissioners. I think the figures in the analysis of the mayor's gifts was 82 times in 24 months. He said he'd tried to procure gifts for some sort of business in 24 months. So if that's what he's reporting, then I imagine the figures of really what's going on to be much, much worse, not only with the mayor, but with all the other areas, offices, commissioners, people doing business in City Hall. It's absolutely gone to the dogs, the city, in the last 15 years, I would say. People who are small business owners, mom and pops, non-corporate, financed up to the yin-yans, just don't have a voice anymore in this city. And I think maybe this proposition that sounds so good doesn't have the teeth that it should have. Maybe it kind of sugarcoats and plays around with the issue, but I wonder if our city attorney's office is not in bed with a lot of the key players in the city here. It seems like a cozy relationship, and I don't know if the city attorney's office has the gumption or the whereabouts to really prosecute and go after these people that really upend our democracy and way of doing business here in the city. And it's so apparent when you look around and you see the landscape, which is completely changed, and hardly anybody can even identify with it or plan on making something, because the gap has just gotten so wide between the people that are connected and the people that are not connected. It never used to be like that in the city. But that's the way it's gone. Anything goes, nothing matters. It's who you pay, and that's who gets to play. Thank you.
Thank you.
David Pilpel. I agree with several of the previous comments about getting this right and not rushing it. Some particular thoughts. I think there is a difference between discretionary approvals and by right or ministerial approvals, and there are pitfalls in both sides there. There are ministerial approvals that may be problematic from an ethics perspective, and there are discretionary approvals that are not so problematic, and vice versa. So I think it's important to understand, as much as one can, the sort of breadth of the type of approvals and contracts and permits and licenses and entitlements that the city grants, and the potential for problems, and really narrowly tailoring these restrictions to those kind of actions that one would want to restrict or prohibit, and less so on the other things. But that's a very complicated area. You've already discussed briefly legal risks and some operational and practical considerations. There may be instances as well where disclosure is more appropriate, and again, restrictions or prohibitions may be less important. Conversely, there are instances where the prohibition makes more sense and disclosure is less important. Unintended consequences are important here. And just by way of example, certainly building a huge building, whether it's a nonprofit housing developer or a for-profit office tower or any number of things, certainly provides the possibility of problems in disclosure and reporting and contributions to officials and candidates. Whereas a reservation permit at Recreation and Park for a picnic table in Golden Gate Park for someone's birthday party, I would think shouldn't raise the same level of concerns. It might if you're able to get the table that you want and you can just call Phil Ginsburg and work it out the day beforehand. But in general practice, if there's a process for tables or for other types of things around town that's generally available to others, and you can list out those examples, that shouldn't rise to the same level of concern as these multi-million-dollar buildings. So to summarize, I agree with the comments that have been made so far. I think we need to work this through IP meetings and perhaps a few rounds before the commission. And again, we shouldn't rush it. We should get it right. Thanks very much. And Kyle did a great job.
Thank you. Any further public comment on this? All right. Well, then we'll now move to agenda item 5, discussion of the staff's enforcement report, an update on various programmatic and operational highlights of the enforcement program's activities since the last monthly meeting. And there's an attachment of the April 19th, 2017 enforcement report with other attachments. Director Pelham.
Thank you. Thank you, Chair. So this month, I was very busy working on the Proposition J memorandum with Kyle and preparing for his arrival with doing some preliminary research. So for the most part, that's what I did for the month of April. I did manage to squeeze in some record retention work. The City Attorney's Office and the Controller's Office in the last 60 days or so has issued new guidance and revised language for the record retention policy. So I continue to rework that and submit it out to all the parties that would need to approve it for their approval. Otherwise, our investigative matters, the complaints that we've received has slowed down. We're not receiving as many as we were before, so the number of matters in preliminary review isn't raising exponentially. They just need to be knocked out. So Leanne will talk in her report about our new hires coming on board. I'm very excited about this, and to just really get down and get up to our elbows in complaints. A couple of notes. On page 3 of agenda item 5 is a table for the status of outstanding penalty installment payments. I note that the outstanding balance for Kim Shri Mafis's 2 committees would be announced at this meeting because the fines collection officer was out sick when this report was being prepared. And the amount is $500 for both of those committees. So $500 remains outstanding, and she's under a stipulation to pay that amount in $50 increments per month, so we'll continue to monitor those payments. But the good news, Stuart Shuffman paid his penalty in its entirety now, and so he will no longer appear on the report.
Who isn't?
Stuart Shuffman. We entered into a stipulation.
That's paid?
Paid in full.
Okay.
Yes. So I'll be happy to answer any questions about any of the charts that we've attached with the number of matters in preliminary review or that are logged as formal complaints. And as you know, we can discuss some of those matters in detail during the closed session.
Ms. Bloom, I apologize for not recognizing you earlier in regard to this being your agenda item. I also want to acknowledge, though, that you indeed, along with Kyle, put in a tremendous amount of work on item 4, and that's appreciated.
Thank you.
The volume of your work each time we see you is just very impressive.
Thank you.
Commissioners. Commissioner
Go ahead.
Commissioner Chin.
Yes, so maybe, Leanne, you'll get to this in your report. I don't want to steal your thunder about the new staff who's joining us. But I had a question regarding, just as a general matter, the number of complaints, and that, as we can see on page 5, I believe that we've got one matter that's greater than 24 months, and then another 13 that are anywhere from 16 to 21 months. So my question is that once we have a full complement of staff on board and up and running, is it feasible to set a goal for reducing the number of matters that are outstanding, and certainly to take the ones that are the most aged and move those forward so that we can then that we can measure ourselves against those targets?
Yes, absolutely. So when I had an investigator in a little bit going into after she left, I knocked out the 2013 matters for exactly that reason. The 2014 matters are definitely on my next target list. I went through and divided up these complaints and made assignments for each of the investigators that are coming on board over the next couple of weeks, made sure to give them an equal amount of the 2014 and 2015 cases. And I'm going to have those obviously be their priority. I hope that we can, a lot of investigative work was done on those cases. I think that they're, for the most part, ready for probable cause hearings or stipulation offers, so they shouldn't be too difficult to knock out, so to speak. So I'm hopeful that we'll have a busy summer in that regard.
Fantastic.
Commissioner Cobb.
Thanks, Mr. Chairman. This is from Chris Jackson. Status, writ of execution prepared by the attorney for the Bureau of Delinquent Revenue.
Correct.
Okay. And then you've got CSM, you've got one number for ethics. What's the CSM?
That I don't know. Oh, Superior Court case number. Is that right?
Okay.
That would make sense because they have a judgment against him.
All right. On Norman. Next step is escalated enforcement. What's that mean?
I believe that what that is, they send a lot of letters. You might recall when they came and spoke to us about their process.
But what's the next step? Filing suit?
Yes, I would think
All right. So, and it's within the small claims court jurisdiction.
Right.
All right. Squarey. Mr. Squarey, at least in my active years, was a well-to-do businessman. This indicates that is this again the Bureau of Delinquent Revenue?
Yes, these status updates are from the Bureau of Delinquent Revenue. Word for word, I just copy and pasted them.
Found new address and employment data. I don't know. I would like to ask you to ascertain for me what the address and employment are. Next is Urbano. Client agreed to repayment agreement terms. Who's the client? Us?
Not in that case, no.
All right. Then
I think that they probably are referring to the person they're collecting from.
I wouldn't call that person a client. I'd call that person a defendant. Client agreed to repayment agreement. Can we ascertain what those terms are?
Yes, we have that right under our MOU.
All right. And then we've got the famous Mr. Jackson, who's in here twice. Almost similar amounts of money. I would like an explanation as to what the enforcement efforts comprise. And then the last one, Sweet, client again, has property. What kind of property? Real property or personal property? And if it's real property, why isn't it, well, there's no judgment yet, apparently. Is that accurate?
That's accurate.
Could you ask? I would like to know why there is no judgment.
I might be able to answer that.
This is this is from December, I see. I thought it was from 13. It's last December. Okay.
I think from their presentation that they gave when they came to the board or to a commission meeting, they indicated they wouldn't seek. There were a lot of letters that over a period of time, and that we wouldn't get to the point of an escalated enforcement action, which would be some sort of court action for 6 months at least. So they're still within that 6-month period.
Well, it's out of our jurisdictional power. I wouldn't wait 6 months.
I know.
I'm not going to. They'll get a judgment, and if there is real property, maybe it's collectible. Thank you.
Any further comments or questions by members of the commission? Okay, we'll take public comment on this then.
Thank you. Elena Schmidt with Friends of Ethics. Also, just want to acknowledge the report, the clarity of the report, and the fact that we have it out in the public and for the past number of months so that we understand what's happening with the enforcement actions. I guess I would like to add another section to the report that's given, and that section would be other public agencies that are taking enforcement action. That I think that would add to the public transparency of the fact that there is an enforcement community out there. I'm thinking about the FPPC. I'm thinking about other federal, state, and city agencies that take enforcement actions on ethical issues. For instance, the FPPC at the last meeting took up the stipulation on the San Francisco Latino Democratic Club and their slate mailers. If we could add just a simple statement of this action is going on, it would reassure the public that, in fact, it's not all the Ethics Commission that has to take enforcement actions, but that there are other enforcement agencies that are doing some work for the public. So it's just a point of information for the public.
Thank you.
David Pilpel. Elena makes a good point. I agree with that. I just looked up on the computer very quickly. You can find the Chris Jackson case if you start at sfsuperiorcourt.org and flow through online activity and case number query and all that. It does suggest that there was an abstract of judgment back in 2013. Doesn't yet indicate a writ of execution, but some steps have been taken. I think in the BDR chart.
Well, excuse me.
Sorry.
Would you check that, please, Ms. Bowman? Yeah, good. Thank you.
On the BDR chart going forward, I think it would be helpful in the status box, and it's great to have that so, there's a little narrative as to what's gone on in the past month or two, to just indicate the last action date. I don't know that BDR has to update this every month as to each case, but certainly when there's something new to report, to just indicate that last action date. And if there is something, clearly the Commission is a lot more interested now in what's happening with these matters referred to BDR, and that's good so that they don't just go away and disappear. You're very concerned, as well you should be, that there's attention paid to all of these things, and that hopefully we get to the point in the not too distant future where this list is reduced and people get out of the doghouse. We want them to pay up, as Mr. Shuffman did, and turn in their forms and do all the things they need to do and get off the list. Otherwise, the report is great. Thank you very much.
Commissioners, City Attorney's Office. Yeah, I'm just an interested member of the public, but my recollection of the matter was that it stemmed from a civil grand jury finding that it was so rampant in City Hall, the pay-to-play politics, that something needed to be done, and henceforth, here we are trying to do something about it. And I think you guys have done a great job, but once again, I just wonder if there's a conflict of interest with the City Attorney's Office writing this legislation and, their close ties to the people in City Hall. That's why I think it's even more important that we have such splendid commissioners that we do have that can make sure that this is not torpedoed or there's not any big loopholes that people can swim around and get through and ultimately deceive the whole purpose of what this is about, this proposition, which is to level the playing field in City Hall and give the small underdog an opportunity at getting a foot in the door and not being swamped by all these special interest groups, so forth and so forth. So I'd like to show up at the meetings in 25 Van Ness. It's kind of short notice. I'd also like to, make written observations, objections to the proposition. But once again, it seems like it's being hastily kind of pushed through all of a sudden at the last minute. Thank you for your time, and thank you for listening.
Thank you. Any further public comment? If not, we'll then move to agenda item 6, discussion of the executive director's report, an update highlighting various programmatic issues and operational activities of the commission staff since the previous monthly meeting. That covers a range of topics such as the commission's budget, policy developments, outreach activities, audit program, and future staff projects. Any of these subjects may potentially be part of the director's presentation or discussion by the commission. There's an attachment dated April 19th from the executive director's report and further attachments. Ms. Pelham.
Thank you, Chair. Under the first item, staff news, we had a very, very busy month. I do want to say that, first off, that we were very sad to say goodbye to one of our longtime staff members, Shaista Sheikh, who was our assistant deputy director and over our operations and audits program, had been with the commission 19 years, and she decided to move to another department in the city to help roll out a new major accounting program for the city that's going to have an impact agency citywide. And so her last day in the office was April the 14th. We were very sorry to see her go, and we miss her already, but we know that she's a phone call away. So that position is one that you'll see on the chart is now added to the list of vacancies that we'll have to work with in the months ahead. Separately, as we introduced earlier, Kyle Kundert came to our office starting April the 10th, so he's been a very busy staff person as well. We look forward to having his insights and research abilities and mind applying forward on all of the policy issues that come across your packets each month. Also very interested and very happy to share news on behalf of Deputy Director Bloom as well, that we have now 3 investigators who will be joining us today. If I could ask Tanya Smith to stand. Tanya has experience directly in this area, having worked for the Fair Political Practices Commission, and she joined us starting today. So the good news is we hope that she'll be back tomorrow as well. Jeff Pierce is starting with us on May the 8th, and Eric Willett, who is one of our current auditors, will also be joining. He's going to transition with the audit program for a bit longer, and then we'll join the enforcement staff in the early part of June. But this is a tremendous group of folks who interviewed through our competitive exam-based process, and we're very excited to be putting together a new team and very, very excited to be really getting to thorough and more timely investigations for your resolution where warranted. So we're very optimistic that we will be bringing good work to that area and delivering on our mission. Table 1 shows the, I should also mention we have 2 new staff members, temporary staff members, Alexis Trejo and Cheryl Lee, also working with us between now and the end of the fiscal year to help us get through some of the paperwork burden that we've got and make sure we can be efficient in our operations. Table 1 shows the positions that are vacant and that we are continuing to work with. As Kyle has now joined us with your policy direction on Prop J and other issues as they come down the road, we're going to be taking a close look again at the policy plan for the coming fiscal year to try and figure out from you and others if this document layout is working, if there's something that we can do to change it, and also to hopefully bring back a good sense of when interested persons meetings and others will be plugged into the issues. So we want to make sure this is working for you and the public in terms of expectations and timeframes for all the issues that we've got on the agenda coming up. So any comments on that going forward would be very helpful. And the last note that I would make is in terms of outreach, we are planning to bring next month for your information a report on what we learned from this year's annual filing process for Form 700s, the financial disclosure process. As you know, we've been working very closely with other departments and groups to start identifying concerns and ways to surmount concerns about electronic filing for all designated filers for Form 700. We think we've learned some really helpful information over this past year's filing process, and so we will be bringing some information about this year's experience, what we've learned from it, and what we hope to get out of it in terms of our policy moving forward. So that's some information that we look forward to sharing with you next month as we tee up the proposal to extend electronic filing to all designated filers for the Form 700 process. And with that, I'm happy to answer any questions that you might have. Excited to keep moving on our hiring front over the next month or 2 or 3.
Thank you, Director Pelham. Commissioners? Commissioner Kopp.
I don't know that you have to be a specialist in the civil service, but why is the education and compliance officer exempt, and the others, administrative analyst, senior administrative analyst, not exempt.
Yes, that's a good question. The position that was vacated, our what we call our 1844, was created as an exempt position. So it continues to be exempt.
How long ago was that?
I believe in the mid-2000s when the campaign finance, the public financing program was created.
It's historical.
Yes.
Okay, thanks.
Any public comment on this agenda item?
Larry Bush, Friends of Ethics. Again, another good report from the executive director. The report also makes mention of a forthcoming policy on document retention, and we would like to recommend that advance copies of that document retention policy be circulated, and that it also be subject to at least a virtual interested persons meeting. You know, it's possible that we can do an interested persons meeting, I think, by inviting people to submit comments rather than actually having a meeting where bodies have to show up. But the world of documents that can be retained and released has changed with recent California Supreme Court decisions on emails. It also is an issue of texts that can be released. And along with that is the importance of timeliness in releasing those retained documents. So we see right now cases where emails have been released showing that communications took place actually during a vote at a commission or at the board, and people changed their vote as a result of the messages that they received. So it'd be a good idea not to have to wait 10 days to find that out, because there would be a second vote before that, and then it would be done. Thank you.
Thank you.
David Pilpel, I was just looking up the charter provision. I think it's somewhere in Article 10 that has lists the exemptions for positions from civil service, and it's probably a Category 17 or 18 exemption for direct reports to a department head. But whatever, it's just obscure stuff. Reviewing the report very briefly, I appreciate the staff that's been hired, look forward to working with them. I just wanted to observe for a second that I think there's been a good mix of people from outside with relevant experience and interest, and people from within the department hired and promoted. And same thing with people departing, people leaving for other opportunities with the city and other opportunities outside the city. So I think Leanne's done a great job of continuing to attract and retain good talent, and we expect a lot out of them, and they're going to deliver. So that's in terms of staff. The one thing I think I noted on the policy plan, the record retention and destruction ordinance update, which really should be records management policy, I think Jessica's report indicated that would be back at the commission in June, and this still indicates May. And I've been providing some input on that and hope to continue doing so. But I don't disagree with Larry's comment that we should get that out there so people have a chance to look at it more than 3 days before the meeting. Thanks very much.
Thank you. Any further public comment? Okay, what I'm going to do now is, even though we have the next one is listed as agenda item 7, in order to really deal with it coherently, since we have in it as part of it item A of 7, public comment on all matters pertaining to agenda item 8. I'm going to take agenda item 8, and then we'll go back to 7, which is going to be a closed session. And so that is going to be discussion and possible actions on items for future meetings. And I think this would dovetail into what Commissioner Kopp had been talking about earlier in regard to some things that you might want to have agendized for the next meeting.
Chair, sorry.
Yeah.
That's actually a typo, and I apologize for that. I should have mentioned it during my report, but that 7A should be agenda item 7, and then actually in subsection C, the number 110 should be 42. Those are a couple of typos that we caught after this went to press. I don't think that changes your decision at all to move on to 8, but I just wanted to make you aware of that. So I apologize.
Thank you, Ms. Bloom.
Yeah, Mr. Chairman and Commission members, I would like to request our attorney to prepare for consideration at our next meeting legislation to remove the city attorney as the attorney for the commission, and language authorizing use of you as our attorney. Or if
you being
you're
Ms. Bloom,
too busy.
You being Ms. Bloom, for the record.
Yeah. Or if you're too busy, then I guess we've got to get another position out of the budget from the mayor and from Civil Service Commission or whatever it's called now. But as I have indicated earlier and said earlier, the time has come to recognize that the city attorney cannot serve two masters. And we learned that rather early in law school. And the city attorney shouldn't be forced to go into contortions to serve two masters.
Okay, so Commissioner Kopp, you'll work with Director Pelham on the wording of that agenda item for the next meeting. Any public comment on, or excuse me, Commissioners, any discussion relating to further items for further agenda meetings?
I believe, and Director Pelham, correct me if I'm wrong, that the budget will be presented at the next meeting for the upcoming fiscal year?
Yes, conversations have been continuing to be underway. We should have more news to report next month, and I'm optimistic that we'll be having resources to help do our job in a stronger way.
Thank you.
Okay, do we have any public comment then on matters pertaining to agenda item 8?
Larry Bush, Friends of Ethics. Just a footnote to Commissioner Kopp's point about an attorney that's dedicated to the Ethics Commission exclusively. As I recall, within the charter, and when you get a write-up back, the charter allows the Ethics Commission to name an outside attorney, but only with the permission of the city attorney, where the city attorney feels there's a conflict. So what you might do as a step, since otherwise you require a charter amendment, and that means 6 members of the board and all the rest of it, is ask for a ruling from the city attorney that when there will be a conflict that will allow the Ethics Commission to name an outside attorney and, if necessary, include funding to pay for a contract. I understand that John Kecker may be available.
May I comment on that comment?
Certainly.
Thank you, Mr. Bush, for your insight, as always. I don't want us spending money on outside attorneys. There's enough money spent on outside attorneys. I want us to have our own attorney, a city employee who answers to the Ethics Commission. And I'm aware of the fact that departments, I guess under existing city law, can ask the city attorney for permission to retain an outside counsel. I don't want to have to do that. I'm satisfied with our attorney.
Thank you, Commissioner Kopp. Any further public comment? Mr. Pilpel.
David Pilpel, just a further thought on this. Certainly there are existing provisions that allow you to get outside counsel in the circumstance of a conflict with the city attorney's concurrence, all that. if what is being suggested is a ongoing change so that there would be a staff attorney designated to advise the commission, in my view, just hearing this tonight, I think that would require a charter change. And I would note that there are at least 2, probably no more than 2, departments in the city that have designated attorneys to advise in addition to the city attorney, and those would be the treasurer tax collector, who has their own attorney, and the sheriff, who has their own attorney, and actually an assistant legal counsel.
Not singular. 3 attorneys.
Right, multiple
3
attorneys.
3 attorneys.
Yes.
At great cost to the taxpayers. Mr. Pilpel, I said I contemplated that it would require a change in the charter.
Absolutely. And that's a good debate that should be had. I look forward to that. Thank you.
Thank you.
Commissioners, City Attorney's Office, member of the interested public. I'm just wondering what the attorney-client contract looks like between the city and the Ethics Commission, and if there is one, and what clauses are in it, and what teeth that has, because obviously whoever's representing the Ethics Commission should sign off on the fact that they're not going to compromise, jeopardize, or in any way substitute something else other than the legitimate mechanism that you're trying to achieve here. And that should be maybe made available to the public, that attorney-client contract. And, it can be amended or so forth. And, if the attorney doesn't seem to be above board, then they can be replaced or sanctioned or so forth and so forth. But there's just one point of view that I'm putting out there, because obviously, attorneys are so political and so forth. So it could be a starting ground for leveling the playing field. Thank you.
Thank you.
Mr. Chairman, since this is being televised, I ought to make it clear there is no contract between the Ethics Commission and the city attorney. There's no contract between any city department and the city attorney. The charter of the city and county of San Francisco makes the city attorney the attorney for city business and city departments, with the exceptions noted by Mr. Pilpel. And that is consistent with the charter section which established the Ethics Commission 20 years ago. There is no contract.
Thank you, Commissioner Kopp. Any further public comment on this? All right, with that then, we're going to move to agenda item 7, and I'd ask whether or not there is a motion that we go into closed session.
So moved.
Okay. All those in favor of the motion?
Aye.
Oh, we have to have public comment, excuse me. Public comment on this item. There is no public comment, so all those in favor of the motion that we go into closed session, please say aye.
Aye.
Those opposed? The motion carries. We're now in closed session. We'll take a 5-minute break. That's okay. 2-minute break.
SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television.
I think. Yeah.
Surprised he's
Yeah, he's a pretty good
hear from me. He was such a gadfly on it. Bardis, remember John Bardis? Hadn't heard of her.
How'd you know John? Just from the board?
Yeah. Oh, yeah. I got a kick out of him.
And he has a brother, Chris, who settled in Sacramento.
Okay, we are back in open session, and we have had public comment on agenda item 8. Is there a motion to adjourn? Oh, first, is there a motion to reveal or not reveal what we did in closed session?
I move not to disclose what we did.
Okay. All those in favor of the motion say aye.
Aye.
Those opposed? Motion carries. We will not disclose.
And I move we adjourn.
Second.
All those in favor?
Aye.
We are adjourned. Thank you all very much.
It's not bad.
Yeah.